we will discuss Article Article 23 and Article 24 of the Constitution, that is dealing with right against exploitation. Article 23 and 24 is one of the important rights guaranteed by the Constitution. So, what is Article 23 and 24? Article 23, prohibition of traffic in human beings and forced labor. So, Article 23 is one of the important rights which deals with the traffic in human beings and forced labor. So, what is the traffic in human being and forced labor? We will discuss. The second part of this article declares that any contravention of this provision shall be an offence punishable in accordance with law. Clause 2 of Article 23 deals with that it is the per, it permits the state to impose compulsory service for public purposes, provided that in making so it shall not make any discrimination on ground only of religion, race, caste, class, or any of them. So Article 23 of the Constitution deals with the forced laborers, bonded laborers, beggars. So Article 23 of the Constitution strike of traffic in human being, whether slave is included in Article 23. Slave is not specifically mentioned, but it is in the word traffic in human being. So traffic in human being means selling or buying a man and women like goods and include immoral traffic in women and children for moral or other purposes. Article 35 of the Constitution empower the Parliament to make law to enforce Article 23. So by invoking Article 35 of the Constitution, Parliament has made the law the suppression of immoral traffic in women and Girls Act 1956 for punishing the acts which result in traffic in human beings. Article 23 of the Constitution is available not only against the state but also private citizens. So Article 23 is available against the state government as well as the private person. So we'll discuss one of the landmark case law regarding Article 23. People's Union for Democratic Rights versus Union of India. This is landmark case law. In this case, Supreme Court has scrutinized the has scrutinized the scope of Article 23, and Supreme Court has held that Article 23 is a wide enough, unlimited, and strike at traffic in human being and beggar. So Article 23 of the Constitution deals with it is not merely beggar, which is prohibited by Article 23, but also all other form of the forced labor. So Article 23 deals with all kind of exploitation. So Article 23 is a wide enough, broad enough to cover all kind of exploitations. So what is bonded labor? What is forced labor? So it is included in Article 23. So Article 20, what is the mandate of Article 23? Mandate of Article 23 is to abolish bonded labor, to abolish forced labor, to abolish slave trade. This is the object. So what is beggar? Beggars means the person is doing the service without payment, without, and it is not voluntarily, then it will be considered as beggar. Beggar. What is bonded labor? The person is doing work for the past date. So bonded labor system is there. It is try to abolish the bondage. What is forced labor? Forced labor. Forced labor means person are not getting the minimum wages or not doing a, it will be not getting the minimum wages. So this is the definition of the under Article 23 of the Constitution. So we'll discuss landmark case law, that is Sanjit Roy versus State of Rajasthan. In this case, it has been held that payment of wages lower than the minimum wages to the person employed on the payment relief work is a violation of 23 of the constitution. The person did not get minimum wages. The person is employed by the government, government or state government, government. The person who is affected by drought or scarcity condition, the state cannot pay him less wages than minimum wages on the ground that it is given them to help the meet of the female situation. The state cannot take advantage of their helplessness. So, under Article 23 in Sanjit Roy versus State of Rajasthan, even though the person's help is provided by the government or state government or central governments and work is provided by the governments, so they should get minimum wages. If the minimum the if the government is paying less than minimum wages, then it will be considered as the exploitation of the exploitation, and Article 23 will be attract will be applicable, will be invoked in that case. So it is a constitutional duty of the state to protect Article 23. Against important landmark case law we'll discuss, that is Dina versus Union of India. In this case, it has been held that labor taken from the prisoner, labor taken from the prisoner without paying proper remuneration was forced labor and violative of Article 23. So any labor taken from the prisoners and they are not getting the mm, minimum payments for whatever he has done, then it will be considered as a forced labor and Article 23 will, will be violated in that case. Violated. Next, in this case, Supreme Court has held that prisoners are entitled to payment of reasonable wages for the work taken for, and the court is under duty to enforce their claim. This is the held in Dina versus Union of India. Next, Bandhu Mukti Morcha versus Union of India in 1984. Supreme Court held that when action is initiated in the court to public interest litigation alleging the existence and bonded labor, the court should welcome it. It may give the government an opportunity of examining whether the bonded labor system exists and as well as to take the appropriate step to eradicate the system. It is the constitutional obligation to eradicate bonded labor system. Unfortunately, no serious effort was made to give the effect to this article. So it is only in 1976 the Parliament has enacted bonded labor system. So Bandhu Mukti Morcha versus Union of India Supreme Court has expressed their view that if the public interest litigation is filed by the persons for abolition of the bonded labor or to scrutinize the to examine the condition of bonded laborers, the state government should welcome to such a public interest litigation. It will give the opportunity to state government whether bonded labor system is exist or not in the society. And state government should take active role to protect bonded labor system. It is observed in Bandha Mukti Morcha versus Union of India in 1984. Next important landmark case law. So these are the case laws on Article 23. Now we will move to the Article 24. What is the Article 24? Article 24 of the Constitution deals with the Article 23 of 24 of the Constitution deals with the prohibition of employment of children in factories. So Article 24 of the Constitution prohibits the employment of the children below 14 years of age in factories and hazardous employment. The protection is given to the children. Why the protection is given to the children? Children are considered as asset of the nation. Children are considered as the wealth of the nation. So children should develop fully. The children are vulnerable section in the society. They should get proper environment. They should be educated. They should get in education. So till the 14 year is very important. So they should not be employed in hazardous workers. There is a constitutional protection is given. So we will find number of laws to protect the protect the child's juvenile justice act is there. It is you will find the rehabilitation provisions, neglected children's provisions, children on the streets. So there is protection to the juvenile you will find under the juvenile protection acts. So against you will find factory acts is there. Factory acts it prohibit factory acts it protect the childs from give the protection against employment of children's act 1930 act is there. 1938 it also prohibits Indian Factories Acts, Mines Acts, Merchant Shopping Acts, Motor Transport Workers Act, Plantation Labor Acts, Bidi and Cigar Workers Act 19 prohibit the employment of people below certain age. This article, however, does not prohibit their employment in any innocent and harmless job or work. So, one of the landmark case law we will discuss that is MC Mehta versus State of Tamil Nadu. This is the landmark case law. In this case, Supreme Court has laid down certain guidelines. Guidelines. What are the guidelines? We will discuss that guidelines. MC Mehta versus State of Tamil Nadu. Supreme Court has laid down the exhaustive guidelines. State authorities should protect the economic, social, humanitarian rights of millions of the children. State authorities should protect the economic, social, humanitarian rights of the millions of children working illegally in public and private sector. Working illegally in public and private section. So this is was MC Mehta versus State of Tamil Nadu. This was the case under Article 32, Sivaksi Crackers Factory case. Number the court direct the setting of the child labor rehabilitation welfare fund. In this case, court direct the setting of the child labor rehabilitation welfare fund. Ask the offending employer to pay for each child a compensation of 20,000 to be deposited in the fund. Next guidelines to appoint adult member of the child's family if they are unable to appoint a and if they are unable to provide the employment then pay the compensation of 20,000 each size each child. The next guideline was that state government and central government should pay 5,000 or other 5,000 to each children's and state and central government should give the employment to the adult member. If they are unable, then 5,000 should be given. So these are the guidelines that done by the Supreme Court in MC Mehta versus State of Tamil Nadu. Next landmark case law, People's Union for Democratic Rights versus Union of India decided in 1986. In this case, the Employment of Children's Act 1935-38 was not applicable in employment of children. Was challenged whether the Employment of the Children's Act 1938 was not applicable in case of employment of the court rejected this argument and held the construction work is a hazardous employment and therefore under Article 24 no child below the age of 14 can be employed in the construction even if the construction industry is not specified in the schedule to the Employment of the Children's Act. The Bhagwati Justice advised the state government to take immediate step for inclusion of the construction work in the schedule to the Act. So these are the guidelines laid down in this case. Next, in Solar Hydro Project versus Jammu and Kashmir, court has reiterated principle that construction work is a hazardous employment and children below the 14 year cannot be employed in this work.